Welcome to Fasken's last session. This is part 2 of our PDAC mining series. Very excited about today's session. I'm Michael Barassa. I'm with the Global Mining Group here in Toronto. There's a slide up on your screen. It's just that I think background is just things you can fill out in terms of a survey and so forth. Today's session, I think, is really great on Indigenous litigation. We have colleagues today from our Toronto office, Vancouver office, and Calgary office. So I think there's a lot of good information they're going to share with you. I'm going to turn it over to my colleague, Bridget Gilbride. She's in our Vancouver office, and she's going to moderate today's session, and she's going to introduce the panel. So welcome to Bridget. Over to you.
Good morning from Vancouver, everybody. Thank you for attending. It is my honor and privilege to be here, and I'm sorry that I can't be in Toronto at the PDAC conference, but I'm happy with the advancement of webinars that we can be here virtually and offer this session from across the country. Now, I know we gave an Indigenous session in our March PDAC series, but we thought it would be worthwhile to have another session on Indigenous legal issues, Indigenous litigation, the advancement of the law, Indigenous policy, because for those of you who are familiar with this area, which I assume is everybody to some extent, this area advances almost every day. And the value and importance of this area to project development across the natural resource sector, I really think it cannot be understated today in Canada. So it's a very nice opportunity for us to be able to talk about it, and I think really valuable, and there's no shortage of issues. So we wanted to reconvene a second seminar with a new group of Fasken lawyers. And that sort of demonstrates that our Fasken Indigenous Law Group, we work across the nation together. And so we're hoping our last seminar and this seminar give you a taste of how we work together and the depth that we have across the nation. So on that note, I'm going to introduce our other speakers. The way we've organized things today is that Brenden Hunter will be speaking first, Chris Ray will be second, and I'll wrap us up. We're going to have time for questions at the end. If you can post questions as you go along in the Q&A, we won't be addressing them as we go through it, but we will leave time at the end for a discussion. And we welcome your questions, and we encourage you to post questions in the Q&A, and we'll handle those as best we can. So without further ado, my two colleagues, I'll introduce them both now, and then we'll go into the seminar. Brenden is a partner in our Alberta office in the energy in the energy sector. I've just realized my notes on Brenden have gone, so I'm going to wing it because I know Brenden very well. Brenden is Brenden's great-great-grandfather was a signatory to Treaty 6, and his work is almost entirely and very heavily focused on assisting clients through project approval processes in Indigenous consultation and in economic benefits issues. So, and he's going to talk on those issues. Chris Ray is a partner in our Toronto office. He's a litigation partner. He has broad commercial and civil litigation experience, including quite a lot of work in injunctive and other extraordinary relief, which often intersects with Indigenous legal issues. He's newer to our Indigenous Law Group, and we welcome him, and we're very happy to have him on board, especially with his litigation experience. And he's going to talk about some additional advancements in Indigenous law across the courts. And I'll finish this up. I'm a partner in the Vancouver Law Group. I work in project approvals, largely environmental assessments, environmental permitting and environmental compliance. And a lot of my work does end up being in the courts, defending project approvals through judicial reviews or at other administrative proceedings, and very large intersection with Indigenous legal issues. And I'm going to talk about the advancements of the law in British Columbia, particularly the policy advancements that we're seeing. So on that note, I'm going to pass it over to my colleague, Brenden.
Bridget. Hello, everyone. As Bridget mentioned, I'm a partner in the Calgary office here in Alberta, and a big portion of the work that I do involves getting projects approved, and a big portion of that is entertaining consultation and negotiations with Indigenous groups. So the two cases that I want to talk about today both involve Indigenous economic interests and projects and how the courts have dealt with those recently. Before I get to those, I think the starting point is a bit of a primer. Many of you are familiar with Section 35 of the Constitution Act, which recognized and affirmed existing Indigenous and treaty rights. And what flows from that is the duty to consult. So I want to talk about the duty to consult, the honor of the Crown, and reconciliation, and how those all tie to one another. And the starting point remains the seminal decision in Haida Nation, which was a Supreme Court of Canada decision in 2004. And one of the paragraphs in that decision that gets a lot of attention is paragraph 39. We all know that the duty to consult, the trigger for the duty to consult is quite low. If the Crown has knowledge, constructive or real, of an Indigenous interest or right that could be adversely affected by a Crown decision, the duty to consult's triggered. Then you look at, okay, what is the scope of that duty? And that's where people turn to paragraph 39, and they think the Supreme Court described it as a bit of a spectrum. On the one hand, if you've got a weak right or the decision won't affect the right very much, then it might be just notice that's owed to the Indigenous group. On the other hand, if you've got a strong prima facie case for your Indigenous or treaty right, and in a treaty right that's established, or if there's going to be a pretty serious impact on that right, then something much more might be required. It might approach something like consent. The paragraph that gets a little bit less attention, but I think is equally important, is paragraph 45. And I've bolded the sentence there, which ties in the duty to consult with reconciliation and the honor of the Crown. And the Supreme Court of Canada said, the controlling question in all situations is what is required to maintain the honor of the Crown and to effect reconciliation between the Crown and the Aboriginal peoples with respects to the interests at stake. Well, what does that mean? What type of interests can affect the duty to consult? Nick, next slide, please. And this begs the question, to me at least, are the honor of the Crown and reconciliation applicable to Indigenous economic interests and projects? And we had two cases in Alberta last year that tackled this question square on and answered it in the affirmative. So the first case that I'm going to talk about today is the AltaLink decision, which came out in October of the last year. It was an Alberta Court of Appeal decision dealing with a new 240 kV transmission line project and how it was traded from a rates perspective by our commission here in Alberta. The second case that I'm going to discuss is the Ermineskin Cree Nation case, which came out in July of last year, which was a duty to consult case dealing with the Coalspur mine, the Vista mine in Hinton, Alberta, and Ermineskin's economic interest in that project through an IBA that they had negotiated with the project proponent. So I'll start with the AltaLink decision. Nick, next slide, please. In terms of background, in 2007, AltaLink applied for permission to construct a new transmission line from Pincher Creek to Lethbridge, Alberta. The most direct route, as it were, to get from Pincher Creek to Lethbridge was to cross two different First Nations reserve lands, the Piikani Nations reserve lands and the Blood Tribes reserve lands. And in 2009, the commission approved that route, which was preferred by the proponent, AltaLink, at that time. And AltaLink's evidence was that by constructing in a more direct, shorter route between Pincher Creek and Lethbridge, it saved Alberta ratepayers approximately $32 million. Now, one of the reasons that both First Nations provided their consent to have the route placed across the reserve lands was an option that they negotiated with AltaLink to acquire up to a 51% interest in those transmission line assets that cross the reserve. Those options were both exercised by 2014. So limited partnerships were created for each of the reserve entities, Piikani Link, a limited partnership, and Kenai Link limited partnership. And under regulatory law in Alberta, if you're going to take regulated utility assets and transfer them to anybody else, you require commission approval. So the limited partnerships and AltaLink applied for those approvals and were granted them in 2018 on a condition that the tariffs for those new entities, those limited partnerships, as part of their tariff applications, they could not include the incremental external auditor and commission hearing costs that were included within the tariffs. And that was in the order of about $60,000 per year is what it was estimated that those incremental costs would be. Under the commission's interpretation of its no harm test, it found that it couldn't look back in time. It couldn't go back to the fact that ratepayers saved $32 million routing this line across the reserve. It could only look forward. You know, how are ratepayers now and into the future going to be better off through this transfer? And the commission found that extra $60,000 that it's going to cost every year is not in the public interest. Next slide, Nick, please. The majority of the Court of Appeal disagreed. It found that the commission committed a legal error by failing to consider all relevant factors, including the cost savings that were experienced by ratepayers from routing that transmission line across the reserve. The majority accepted that you had to look at all positive and all negative factors resulting from the project. And through the creation of the limited partnerships, the Court of Appeal found that there were other future benefits that would be experienced: employment benefits, future business opportunities. The majority found that the fact that First Nation businesses would now be operating on the grid had benefits. And it also found that there'd be ongoing environmental benefits. The southern portion of Alberta has a lot of renewable energy, such as wind, that would be coming onto the grid. The fact that the transmission line was shorter meant that it had less environmental impact than it would otherwise. Speaking for the majority, Mr. Justice Watson stated, projects that increase the likelihood of economic activity on a reserve ought to be encouraged. So ordinarily, when an administrative decision is judicially reviewed or appealed, statutory appealed, as was the case in this circumstance, that decision is quashed and the matter is sent back to the decision maker for further or reconsideration. In this case, the Court of Appeal went one step further and actually varied the decision, ordering that those incremental costs of $60,000 every year be included in the respective tariff applications. So that was a bit of an unusual extra step that was taken in this case. There was also a concurring minority decision by Justice Feehan. All of the parties in this case asked the Court of Appeal to clarify, okay, this wasn't a duty to consult case. We've got the limited partnerships involved. They're actually the applicants. So this isn't a situation where they've taken issue with the process because they weren't notified of it or didn't have an opportunity to participate. How do we take honor of the Crown and reconciliation into account in these types of circumstances? What's the Commission's role? And the answer from Justice Feehan was, if an Indigenous collective brings up the principles of honor in the Crown and reconciliation, then the Commission's got an obligation to consider how they apply. The decision contained no discussion of how these principles applied, and therefore the Commission committed an error. So going forward, I think this suggests to us that you don't necessarily need to have a duty to consult in order to raise issues around honor of the Crown or reconciliation. which in my mind is a broadening of where we're going to see Indigenous issues arise in these type of tribunal decisions. Next slide, Nick. The next decision I wanted to talk about was Ermineskin Cree Nation. And this dealt with a coal mine that was developed or proposed to be developed in 2 phases. Phase 1 was approved and is in operation. And as part of that, as a part of getting approval for that, Ermineskin Cree Nation entered into an impact benefit agreement with Coalspur, from which it experienced economic development opportunities and benefits, and in which it supported the project. And it entered into similar negotiations with Coalspur for phase 2 of the project, and entered into a second IBA in 2019, in which it would receive further economic benefits from the project. Very common with these type of projects. The coal mine itself was located in Treaty 6 territory, and it was also located within the traditional territory of Ermineskin. Ermineskin is one of the 4 nations of Masquachis, which are located approximately 400 kilometers away from this particular coal mine. But Ermineskin's got a smaller camp called the Mountain Cree or Small Boy Camp, which was located only 55 kilometers away from the coal mine. So if we could go to the next slide, please, Nick. So when it was decided that Coalspur was going to apply for phase 2 to expand the coal project, the project itself would be subject to a provincial environmental assessment through the Alberta Energy Regulator, but it didn't trigger an automatic impact assessment under the Impact Assessment Act federally. In order for this project to be reviewed further under the Impact Assessment Act, the Minister of Environment and Climate Change Canada would have had to designate the project under a designation order. So there was discussion with that, and there was a process involving First Nations regarding a potential designation in 2019. And in 2019, the minister decided, upon the recommendation of the Impact Assessment Agency, not to designate this particular project. In 2020, 2 First Nations, Stoney Nakoda Nations and Louisville Tribe, which interestingly is one of the other 4 nations of Masquachis, wrote to the minister asking that the decision be reconsidered whether or not to designate that project. The minister then proceeded into consultation with Stoney Nakoda and Louisville Tribe, and in 2020, in what the federal court called a clear about face, then did in fact designate this project through a designation order. If we could go to the next slide, Nick. The interesting thing about the consultation that occurred in the 2020 decision is that the minister didn't include the groups that did not support the designation order, such as Ermineskin, as part of the consultation process. The problem that this created for Ermineskin is that when the designation order was issued, it led to a complete halt of the project of phase 2 of the mine. As part of that, the benefits that would have flowed through the 2019 IBA that Ermineskin had with Coalspur were also suspended. So having their economic interests affected by this designation order, Ermineskin brought a judicial review application against the minister on the basis that the order would either delay, lessen, or completely eliminate the economic benefits that they would have experienced through phase 2 of the project. The minister disagreed, and at the federal court level argued that economic, social, and community benefits aren't treaty or Indigenous rights that would trigger consultation. Next slide, please, Nick. The federal court disagreed and quashed the designation order. the federal court found that the Crown should have been on notice of the fact that Ermineskin, as part of its 2020 process, it already had notice of Ermineskin's Treaty 6 rights, as well as its previous interest in the project through the 2019 process, and yet didn't consult with it or even give Ermineskin notice of the fact that it was reconsidering its decision. Now, the court found that the economic rights and benefits were so closely related to Ermineskin's treaty and Indigenous rights that the duty of consult was triggered. And to me, this is consistent with the AltaLink decision where, that's a pretty low threshold then to trigger the duty to consult. And the 2019 IBI was found to contain valuable rights. Well, the Crown wasn't privy to that IBA. They wouldn't have known exactly what was negotiated between Ermineskin and Coalspur. So to me, that suggests, again, a low threshold moving forward. If you've got Indigenous groups that are supportive of your project and other Indigenous groups are advocating against it, your Indigenous groups in support of your project have an equal voice at that table to be heard. So the court ultimately found that the honor of the Crown and the duty to consult encourage reconciliation by better ensuring Indigenous and treaty rights are protected and accommodated. The court made reference to the Supreme Court of Canada's comment in Rio Tinto and Carrier-Sakani, where the court referenced the reality that often Indigenous peoples are involved in exploiting the resource. And that's been common with my experiences in Alberta as well. One additional comment that I would make is, even though Louisville sought a designation order from the minister, to me, that doesn't automatically suggest that they were necessarily opposed to the project. I mentioned at the outset that Ermineskin had a camp 55 kilometers from the mine, whereas the rest of the 4 Maskwacis reserve lands are approximately 350 to 400 kilometers from this coal mine. It's highly possible, with the close linkages between Louisville and Ermineskin, that one knew about the deal that the other cut with Coalspur and was trying to use the regulatory process as leverage as part of their negotiations with Coalspur. We just can't assume, I don't think, that group wouldn't have necessarily reached a deal with the project proponent either. But because Ermineskin had the camp 55 kilometers closer, the project proponent might have made the determination that they would be more impacted than the other 3 Maskwacis First Nations. We just don't know, but I don't think we should assume that those Indigenous groups were necessarily opposed to the project. This decision has been appealed. It went to the Federal Court of Appeal on May 17th, and the Federal Court of Appeal has reserved its judgment. So we don't have the last word on this one yet, but we'll be watching it very closely. I will turn things over now to Chris, who will be discussing 2 other decisions where the courts have taken a more expansive or generous interpretation of legal rights.
Thanks very much, Brenden. As Brenden mentioned at the outset of his presentation, when he's referring to the Yahey decision of the Supreme Court, one of the constant hallmarks that we see in more recent case law that's coming across our desks focuses increasingly on the importance of reconciliation as being its own underpinning and justification for what we have seen as an evolution of the way that courts are treating Indigenous law issues, that is building and building and building. And that's what I'm going to review in that theme is what I'm going to review in the 2 decisions that I'm going to go over, which are the Anderson and Alberta decision and the Regina and Boyer decision. The first being a decision of the Supreme Court of Canada released a few months ago, and the second, a decision of the Saskatchewan Court of Appeal, also released in 2022. So starting with the Anderson decision, this is a case which addressed the applicable and clarified the applicable legal test in considering applications for what are referred to as advance costs in public interest litigation. What advance costs really refers to is the funding of litigation commenced by a party by the public purse. So that's what we're talking about when we're talking about advance costs awards and the circumstances in which those awards will be made. So a bit of background underlying this decision. This decision involved the Beaver Lake Cree Nation, which is within the Treaty 6 territory. The Beaver Lake Cree Nation is a 1,200 member community near the Lac La Biche area in northeastern Alberta. In 2008, so only a few years ago, an action was commenced against Alberta and Canada, alleging that the Crown improperly allowed Beaver Lake's traditional lands to be taken up for industrial and resource development, which compromised its ability to pursue its traditional way of life. An application was brought in the context of that litigation which was being case managed. An application was brought to the case management judge seeking advance costs in the circumstances of the case. And Beaver Lake made their application on the basis of the existing three-part test, which contained three what are referred to in the case law as absolute requirements. So it's a discretionary test. Court always retains discretion in deciding whether or not to make costs awards of any kind, notwithstanding the test. But absent meeting all three parts of the test, an award will not be granted. So these are absolute requirements. And the existing three-part test, which itself wasn't modified in terms of the what those three parts are by the Supreme Court in this decision, as I'll come to, it was what the meaning of two of those branches of the test, what the content of those was expanded by the court. So that three-part test has three pieces, of course. The first is impecuniosity, essentially the inability to fund litigation. The second is a prima facie meritorious case. And the third is that the case involves issues of public importance. And so in terms of the context of this case, the case management judge decided that despite having $3 million, which it had received as part of a settlement of another specific claim, that Beaver Lake was nevertheless impecunious and satisfied the other requirements of the test and granted an award of costs, which required each of Alberta and Canada to fund $300,000 annually to cover some of Beaver Lake's legal expenses, with Beaver Lake expected to contribute the remaining $300,000 or what was left beyond that. Both Alberta and Canada appealed the decision of the case management judge, and the Alberta Court of Appeal allowed the appeals and overturned the case management judge's decision, holding that the judge had made an error in finding impecuniosity on the following lines: that Beaver Lakes had resources, it had revenue, and that it had made decisions to allocate those funds, including the $3 million it had received in settlement of this other specific claim, to fund other priorities. And the evidence that was before the case management judge, which really wasn't challenged, established that there were significant issues facing the Beaver Lake Cree Nation, and that needed to be addressed in terms of housing issues and educational issues and other significant issues that needed to be addressed within the community. But nevertheless, the Court of Appeal found that where the government, the First Nations government, was making decisions about where to allocate money, if it had funds to allocate, that was sufficient to demonstrate that the impecuniosity branch of the test was not met. The Supreme Court, in a decision rendered by the entire court, or for the entire court, I should say, and authored by Justices Karakatsanis and Justice Brown, overturned the decision of the Alberta Court of Appeal, finding that the interpretation of impecuniosity in particular was overly narrow, and that a broader approach was necessary, particularly when considering litigation involving Indigenous governments and Indigenous rights issues, and took the opportunity to evaluate the test as a whole, and then to address it in the context of Indigenous litigation. The Supreme Court noted in its decision that in assessing impecuniosity, so dealing with the first branch of the test, a court has to respectfully account for the broader context in which First Nations governments such as Beaver Lake make financial decisions. In other words, it's not, you can't ignore the reality on the ground facing an Indigenous government like Beaver Lake when assessing whether or not impecuniosity is made out in the circumstances. And the court went on to highlight that deference must be given to a First Nations government which is in the best position to assess its own pressing needs. Next slide, please. The Supreme Court reiterated that when we're dealing with impecuniosity, we're dealing with circumstances where a party genuinely cannot afford to pay for litigation. But in the context of a First Nation government, that would be the case where that government requires funds in order to fund other pressing needs, understood, and this is an important point, understood through the First Nations perspective, meaning, and that's where the deference comes from, which would leave that First Nation unable to fund the public interest litigation. In other words, if the First Nation has to choose between, for instance, dealing with a water crisis and ensuring, clean drinking water, or on the other hand, funding litigation, the fact that it has funds to do either of those things doesn't mean that it's not impecunious. So that's what the court is really getting at and wanted to address with its decision, to allow a little bit more flexibility in the assessment. So when assessing whether to order advance costs, the Supreme Court held that a court must have a sufficient record to, first off, identify the applicant's pressing needs. Second, determine what resources are required to meet those needs. Third, assess the applicant's resources, both assets and income. And fourth, identify the estimated cost of funding the litigation. When talking about pressing needs, one other comment I want to make is that the court went to lengths to explain that although the example that I highlighted would amount to what you would consider to be a bare necessity, pressing needs are not actually limited to bare necessities. And relying on the imperative of reconciliation and the importance of reconciliation, the court highlighted that what is a pressing need had to be understood in the specific context of the First Nation government involved. And so that may shift depending on the situation of different First Nations in different situations. The The Supreme Court ultimately determined that the matter should be remitted back to the case management judge for a new hearing on the appropriateness of awarding advance costs. The decision to remit was on the basis that the case management judge could not have made the determination that she had that Beaver Lake was impecunious in the circumstances. And secondly, based on the evidentiary record, and secondly, that there was nothing, there was insufficient evidence in the record to address the amount of advance costs that would be required to enable Beaver Lake to pursue the litigation. Next slide. So there are a few key takeaways from this decision. So this decision, again, I think is first off highlights the evolution, continuing trend, I should say, of courts and their increasing favor towards a broader approach to dealing with Indigenous legal issues as a general principle. But the decision itself is important on its own, of course, because it expands the circumstances in which Indigenous governments or other parties may have access to advance costs awards, which is beyond what otherwise had been available arguably prior to the decision of the court in this decision. So as I said at the outset, the first part of the test, which is impecuniosity, has been broadened by virtue of this decision in the way, particularly as it relates to litigation involving Indigenous governments and the introduction of a weighing of pressing needs as a fair consideration. And then the other aspect in which the test was modified is that the court highlighted, and you see this in point number 2, that litigation which raises novel issues concerning the interpretation of Aboriginal and treaty rights and the infringement of those rights is more likely to engage the public interest component of the three-part test. We can go on to the next slide. So the second decision I want to talk about is this decision from the Saskatchewan Court of Appeal in Regina and Boyer, which was actually, by way of a little bit of background, a case involving 3 individuals who were prosecuted, 3 Métis individuals who were charged and prosecuted with unlawfully hunting and fishing for food outside of an area which had previously been identified in other litigation as being a traditional hunting and fishing ground for Métis in Saskatchewan, being the northwestern part of Saskatchewan. And at trial, the 3 individuals accused took the position that they were hunting and fishing for food pursuant to their Section 35 rights, and that they were not and did not, it was not appropriate to limit their entitlement and their rights to be narrowly interpreted within a specific area that had already been predetermined in other litigation. Next slide. Of the 3 individuals, 2 were convicted of unlawfully hunting and fishing. 1 was acquitted because the focus of the trial judge was on whether or not the 3 individuals were in fact hunting and fishing within the specific area in that northwestern Saskatchewan area that had previously been identified as an area in which fell within the approved areas in which hunting and fishing from the perspective of the rights where that could occur. The other 2 were found to be outside And the trial judge made his decision heavily relying on the Crown's submission that a prior decision of the Supreme Court in a case named Powley governed and stood for the proposition that you could only look at narrow, site-specific areas only when assessing rights claims, and that it was improper or it was not allowed to look at a broader geographical or province-wide area when assessing those rights. What's notable, this case went up to the Saskatchewan Court of Appeal, obviously. What's notable is that this was the first time that the Saskatchewan Court of Appeal had ever considered the extent to which the Métis could claim a right to hunt and fish for food under Section 35. And perhaps one reason for that is that these cases all originate from provincial offenses, which are dealt with at a much lower level of court, and there are impediments to getting provincial offenses matters up to the Court of Appeal. But I would also suggest that the court's interest in weighing in finally into this area is indicative of the broader trend that I had referred to at the outset, of courts increasingly looking for opportunities to make their mark and address issues which are coming up in this area. So the Saskatchewan Court of Appeal rejected the narrow interpretation of Powley, which had been accepted by the trial judge and advanced by the Crown, finding that a nomadic group may have different rights than a group which claims site-specific rights, and therefore claims did not have to be considered on a site-specific basis only, meaning they could be considered on a much larger geographical basis. Ultimately, the Saskatchewan Court of Appeal ordered a new trial to allow Boyer and Poitras to advance the position that they indeed had a right to harvest broader than had been established in site-specific cases such as Powley and other decisions of the provincial courts in Saskatchewan. So in terms of takeaways, this is this case a good example of, as I said, of the increasing shift in our courts away from narrow interpretations of Section 35 rights claims. But beyond that, and I've included here a quote from the lawyer who acted for the three accused in this case, which I won't read out in its entirety, but I've bolded, two, I think important points where this case is likely to have a broader impact, and this decision from the Saskatchewan Court of Appeal is likely to have a broader impact. So the first is the point about reconciliation and the importance of reconciliation, which continues to be a significant theme in every decision in this area. And as Bridget said, there are new developments on an almost daily or weekly basis. But the second area where this decision, I think, has the potential to have a lot of impact is when dealing with, particularly Métis claims in Saskatchewan. There's a likelihood of this having a broader impact on the duty to consult and the implications for the duty to consult on a much broader and province-wide basis, given the extent of the rights that may subsequently be decided. So we'll be waiting to see what the Crown does in Boyer, whether the Crown ends up prosecuting, or whether this prompts what the Métis Nation is asking for, which is discussions and ultimately agreement with the Saskatchewan government to solve a lot of these similar types of issues, which have been an ongoing issue for many, many years. With that, I'll turn it over to Bridget.
Thank you, Chris and Nick. If you can move to the next slide. I just want to highlight that the cases that Brenden and Chris both talked about are all appellate level cases. And you know, that may have been obvious to you, but I just highlighted in that it really is the case that the courts are taking very seriously the statements in HIDA that Brenden read to you at the beginning about the importance of honor of the Crown and reconciliation. And the courts are really across the country at an appellate level indicating to decision makers that you need to take these into account, and you need to take it into account broadly. It's no longer just about hunting, fishing, and trapping and your use of resources. It's the broader interests of Indigenous groups are being taken into account generally at all decisions. So in Ermineskin, the economic interests, in Beaver Lake, the whole of government approach to the First Nation and everything that they need to consider. So there's a much more broader lens taken and recognition of the role of Indigenous governments. And I think that's consistent with how the policy is also going within the country. And that's mostly what I'm going to talk about. I will talk a little bit about some cases in British Columbia. I have said on the slide here is British Columbia a harbinger for the rest of Canada. In this area of law, the courts in British Columbia have long been the first ones to advance the common law, largely as the Indigenous groups in British Columbia have been bringing these issues to the courts, and that's where HIDA comes from, and that's where Silcotin comes from, and this is where Delgamuukw comes from. So it's been a long trend that the common law has advanced first in British Columbia and now across the country, as we're seeing from the cases that Brenden and Chris just talked about. But British Columbia as a province, the focus right now is in fact on advancing the policy and how the government deals with Indigenous issues. And I would say British Columbia and the federal government, Canada, are walking step by step, pretty closely in the same direction. And they seem to be the two jurisdictions that are taking concrete steps to advance policy that I think will have as much influence on the dealings with Indigenous groups across the country as these cases. Cases can't be ignored. Common law has been really important in this area to advance Indigenous rights, but policy, perhaps some would say policy, is catching up now. On that note, the one case in British Columbia I will talk about, there are other cases coming out of British Columbia. We just simply don't have time to talk about them. You heard about some of them in March. If you went to the March seminar that we had, there's a title decision where private land interests are at issue. There's cases about where the expansion of Indigenous rights into common law torts like trespass and nuisance, and what's the interplay there. Really interesting cases. I won't talk about all of them now. Please, if you want to hear more about them, maybe put it in the Q&A and we can discuss it then. But the one case I want to address is the Yahey case. The Yahey case, I'm sure many of you have heard about it. We did discuss it at March, but it's so important that I think it's worthy of pausing again. And what the Yahey case was a case brought by Blueberry River First Nations. They're in Northeast British Columbia, and they're signatory to Treaty 8, so one of the historic number treaties, which cover most of Canada. But in British Columbia, it's the Northeast section of British Columbia. And this is a map of Treaty 8 on your screen. You can see it's Northeast British Columbia, a whole lot of Alberta, Northwest Saskatchewan, and some of the Northwest Territories. And there's similar numbered treaties in other parts of Canada. And what the Blueberry River First Nation did, and it actually followed the Beaver Lake First Nation, which is the case that Chris talked about, but it followed and got ahead of it. And in fact, has had a decision as that one has been caught up in issues and practical issues, such as the First Nation struggling to have the funds to advance the case. So Blueberry filed this case in order to establish an infringement of these historic treaties by the case law established by the Supreme Court of Canada. It's called the Mikisew test. But in order to establish an infringement, it's not project by project. And that's what the courts have said. And the First Nations have long been bringing when they oppose projects, they bring their judicial reviews, and they've started to assert infringement within those judicial reviews. And the court said, no, this isn't, you can't have infringement determined in this regard. And then in the treaty context, the test is whether you have the ability to meaningfully exercise your treaty rights remaining anyway. And so Blueberry River took that challenge on and said, we don't have the ability to meaningfully exercise our treaty rights due to the cumulative effects of development that the province of British Columbia has approved in our territory. And Blueberry River does sit on the Montney gas fields in British Columbia. So there's a lot of oil and gas development in the territory around Blueberry River. And this was something that we're all watching. And in a 500-page decision issued by Justice Burke in June of last year, she agreed with Blueberry River. And she said the Crown hasn't been taking cumulative effects into account as a whole, right? And they needed to. And as a result, Blueberry River's treaty rights have been infringed. And what's followed from that are two orders that she made, and they're on the next slide. And so these were issued in June, the end of June last year, where the BC Supreme Court ordered that the province may not continue to authorize activities that breach promises in the treaty, or that, skipping to the end, or that unjustifiably infringe Blueberry's exercise of treaty rights. So essentially, this has been viewed, we can have a nice legal discussion on exactly all what these words mean. I won't do that here, but this has been viewed as a halt to project authorizations by the province, unless they can meet the justification standard, which is a stringent standard. So a halt to approvals until the next order is fulfilled. And the next order is a direction to the parties to establish mechanisms to assess and manage cumulative impact of industrial development. And what's happened from this, and this sort of brings me to the policy discussion, is the province of British Columbia decided not to appeal this decision and launched directly into the direction of the court to work with not only Blueberry River First Nation, but they've established a table with all of the treaty First Nations to attempt to establish a mechanism to manage the cumulative effects of industrial development. Those talks are ongoing, but British Columbia did announce they're not appealing, and it's their intent to work with the First Nations and develop a scheme that the First Nations are involved in developing for the approval of permits in Northeast BC. So it really very much is consistent with where they're going in the rest of the province, in that the province is indicating, we're going to do this together with you, First Nations. The province is absolutely, and neither are the First Nations, indicating that this ought to be a halt as a whole. It's intended to be a collaborative working environment where the First Nations are involved in how industrial development moves forward. So not a halt to industrial development. And they want to be involved at a level that is different than what Haida promised them. How that ends up, I mean, I actually view Haida as extremely robust. Meaningful consultation has to be just that, meaningful. So whether it will depart drastically from what I think the Supreme Court of Canada's intention was in Haida, it's hard to say, but no matter what we see now are that the First Nations have a seat at the table, and a prominent seat at the table in the advancement of industrial development. And if you go to the next slide, this was through case law in British Columbia, but they've also implemented legislation, and this is legislation I'm sure you've heard a lot about. And this is legislation, and it's happened in BC first in 2019. Canada followed later on. They've got legislation that affirms the application of the United Nations Declaration on the Rights of Indigenous Peoples to the laws of BC and Canada, respectively. The governments and the ministers who have put forward this legislation say there's 2 proactive steps it requires. And I frame it that way in that, well, it's yet to be seen what the courts say it means. But what the ministers say is there's actually 2 steps as to what this means. This affirm the application and take steps to implement it. And the governments say it means we have to review all our laws and make them consistent with the declaration. And we have to put in place an action plan for government policy more broadly, to ensure it's being taken into account and actively implemented through the various policies and branches of government, and the whole of government approach here, where it can't be isolated off with just Indigenous groups. All of government needs to take this into account. The BC and Canadian governments were doing this work even before the legislation was implemented. I can certainly say that. For those of you who have projects going through environmental assessment approvals, both the BC legislation and the federal legislation, which is fairly new, reference UNDRIP. I believe it's in their preambles for both of them, but they reference UNDRIP, and those legislations, while implemented before, I think in both cases, before this UNDRIP legislation, was efforts to make that legislation consistent with UNDRIP. So they've already started the work on the legislation, but it is ongoing. The question as to what this means otherwise, besides legislation or in the interim until legislation is developed, is an open question. But you'll see on the slides, I do have the words "without delay," and that is because both legislations say nothing in the act will be construed as delaying the application of UNDRIP. So I think UNDRIP is with us here and now. And what that means is likely a change in legislation. But what else it means, I think, is an open question for the courts to tell us at some point. But the third element in British Columbia that I think is very important, and you see this in Canada through the Impact Assessment Act, but not in the UNDRIP legislation. But the third element in UNDRIP, and I will say this is how British Columbia is attempting to implement UNDRIP today, is the ability of the government to enter agreements with Indigenous governing bodies. And so UNDRIP provides for decision-making, the ability of the province to enter decision-making agreements with Indigenous nations. And if you go to the next slide, this is Section 7 of the BC Act. And what it allows for are 2 types of agreements that the Act as a blanket calls decision-making agreements. So it allows for agreements that share joint decision-making. So share the statutory decision-making powers with an Indigenous government. And it also allows for agreements that require the consent of an Indigenous governance body. So 2 types of agreements. We have yet to see any in the first, which will be really interesting when we do see it, because there's lots of administrative law implications that we could talk about, because if you're sharing a statutory power of decision, you necessarily need to make your decision within the bounds of that statute, and so if you're sharing that with an Indigenous governing body, they will have to determine how it is that they make the bounds within the statute while taking their own interests into account, which will be the purpose of entering the agreement. So where does the public interest, I guess, fall for the Indigenous governing body when they're making a decision that affects their nation, but also affects the the public at large. So lots of interesting legal questions. But what we have seen, though, and where the government has entered an agreement just this month, June 6th of this month, BC announced the first agreement under Section 7 of the Act, and they call it a consent-based agreement or a consent agreement with Tahltan, who's in Northwest British Columbia. It's a really interesting agreement. It's worth reading if you haven't done it, although it's 48 pages. So you might want to skim it, but it's worth reading because I will say because of its focus and its narrowness. And maybe we can have a debate as to whether it is narrow, but it's narrow in the sense that this is an agreement that applies to one project specifically. A mining project that is a revitalization of a mine too. So it's not even a new mining project. The proponent, Skeena Resources, has indicated their support for this agreement. It provides clarity on the review process, and it gives Tahltan their own ability or they will be doing their own assessment of the project. So in line with the provincial environmental assessment, we'll see an assessment from Tahltan. And the punchline is in order to proceed, the statutory decision maker is going to need the Tahltan central government's consent. And Tahltan central government will decide at the end of the process whether or not they give that consent. So it's very deliberate, it's very focused, there's a lot of detail. I actually think we can take I think this is an indication of things to come. I think we can take a good comfort in the certainty that they are penning how consent should be required and applied in British Columbia. I think it's an indication that consent is important, but that at least from our government's point of view, and again, I leave the asterisk that it's not clear what the courts will do with it, but at least from our government's point of view, how we implement UNDRIP, and particularly the provisions with UNDRIP relating to the objective of seeking Indigenous groups' consent, is in a deliberate and public way in these consent-based agreements versus sort of a general uncertainty, and that where consent is just simply required as a matter of principle going forward across the board. So this is how BC is trying to balance it. As we know, and Ermineskin shows, frankly, the Indigenous groups are certainly not a homogeneous group. So there's lots of different interests among groups. And again, this is, I think, how BC is attempting to balance seeking consent from groups who are most impacted, while recognizing that perhaps the interests and the views of other Indigenous groups who are also impacted may be different, and trying to balance that. So I think there's a lot to come. I do think British Columbia is the jurisdiction to watch right now. With respect to policy, we're seeing, if you can move to the next slide, another policy move of British Columbia. I won't spend too long on this because it's more for people like Chris and I to deal with. But another move of the British Columbia government, which is consistent with we're seeking consent, we're negotiating, we're giving the not appealing Yahey. Indigenous groups ought to have a seat at the table, are getting a seat at the table, is that British Columbia has followed the federal government, who is the first, about 4 years ago, I believe, to issue litigation directives, which they don't have anything solid. You must do this, but the general scope of the directives is that you must generally take a rights recognition approach. You must not use technical defenses. You must be efficient, and you ought to litigate with the goal of narrowing or avoiding litigation. It puts litigators in a difficult situation because often you're litigating not because you came to court, but because somebody brought you to court. And so balancing how the government manages this when they're the ones brought to court is will be interesting to watch, but I think it is a management directive, and it's attempting to take the whole of government approach where rights recognition is the move forward, and seeking consent of First Nations, seeking consent and doing it in a deliberate way is what British Columbia is trying to move to right now. On that note, I see that our chat, and I can't view the chat. Oh, sorry. Oh, this is sorry. So on that note, I think I'm going to turn it over to the questions. Sorry, I was distracted by a couple of different screens here. If you do have questions, I encourage you to put them into the Q&A.
So Bridget, I had inadvertently responded in writing to one of the questions, and I was reminded that I was supposed to speak to those. So I've got a couple follow-up questions for you, but perhaps I'll respond to one of the questions in the Q&A that was in there, which is, Brenden, explain what a designation order is. What a designation order is where an impact assessment isn't automatically included as the type of physical activity that requires an impact assessment federally, which is quite an extensive process. I think the evidence before the federal court was that it was in the order of 3 to 4 years if you trigger a formal federal impact assessment. What the designation order does is it sends the matter back to the impact assessment agency through a process to decide whether or not further assessment is required of some nature. And through that process, it is possible that a full impact assessment is not necessarily required. And that was one of the defenses that the minister brought up. Hey, this is premature. We haven't decided whether a full impact assessment is necessary yet. As such, we haven't necessarily precluded those economic rights flowing through to Ermineskin. But the court rejected that, saying, no, the result of your designation order was to halt the project. So at this stage, you have in fact impacted those economic benefits. So we don't accept that argument, Minister. Bridget, on the UNDRIP topic, I had a couple follow-up questions for you, and I apologize, I'm putting you on the spot because I haven't given you notice of these, but on the UNDRIP action plans that BC and Canada are preparing, and I want to set aside the legal question as to whether or not consultation with Indigenous groups is necessary legally, but do you know on the ground whether BC had some sort of Indigenous consultation forum as part of the development of those plans themselves, or whether it was done internally? Have they issued a draft that then's going out for comment? Do you know what the status of those are?
I certainly know what the status in British Columbia is. They have issued their first action plan. So we have an action plan in British Columbia. It has something like 89 actions. The litigation directives was in fact an implementation of the action plan. I think I can answer the legal question too, because it's in the statutes. It's in both the federal and the British Columbia statutes that the action plans will be developed with Indigenous groups. So everything essentially implemented by this legislation, including the changing the laws, is expressly, and I would say likely, even if it weren't expressed, probably the courts would rule that it had to be included, but we don't even need to decide because it's expressly needs to be done with Indigenous groups generally. Now, exactly practically how that happened within British Columbia, I don't know the details. Probably people listening, I'm sure there's some people who know more than me. I have a question for you, Brenden, and then I do have a question for you, Chris, on the cases that you issued. In the meanwhile, I will follow the Q&A, so I do encourage anyone else to put questions in the Q&A. But my question for you, Brenden, is Ermineskin, do you think, has it, or do you think it will or ought to change what goes into IBAs that proponents are entering with First Nations, now that we have a court ruling that IBAs in fact can be a reason, a triggering of the duty to consult, and something that have to be taken into account when project approvals are being reviewed. Is this changing the scope, the timing, anything about how IBAs are entered into or ought to?
I'm not sure that it necessarily needs to change the course of action as long as it's clear in your title. Impact benefit agreement suggests to me that there has been an impact, that the treaty or Indigenous interest or right has been affected in some sort of adverse way, but the parties have negotiated a benefit of some sort to negotiate that. To offset that rather. So to me, the fact that they called it an IPA, or if you call it a mutual benefit agreement, whatever name you land on, is as long as you can make the existence of that agreement known, as opposed to keeping the existence of the agreement confidential as well, I think that should be enough to put the Crown on notice that, hey, there's been a deal had here, and you should be consulting with us as well before making a determination against the project, because there's also Indigenous interests in this particular case in favor of the project. So, and I'm not sure, the Crown should take more of a role in it than that, because then are they starting to second guess and take some sort of oversight role as to what is effectively a private party contract with the Indigenous group? It's always open to the Crown, and the Crown's always subject to its own consultation obligations. So I guess it remains to be seen, but I think what we've seen is a pretty low trigger at this point.
And I suppose, and I'm just thinking this, I suppose one of the things that where you ought to consider this as a project proponent are the confidentiality terms around any agreement, because the Crown can't take it into account if they don't know about it.
So you'd clearly carve out that the existence of the agreement could be made known to the Crown or other regulatory authorities in instances where that regulatory authority is acting in place of the Crown or in lieu of the Crown.
And the Ermineskin case actually, I think, relates to the question that's in the Q&A. And the question to the Q&A is about, are the agreements, like the consent agreements, being entered into in areas where there's a large number of overlapping interests? And I say that relates to the Ermineskin case because it shows the different overlapping interests and conflicting interests that may exist. I think the government of British Columbia is starting where there are not overlapping interests. I mean, I don't actually think there's any doubt about that. And because it's a lot more difficult with overlapping interests to determine what exactly will be required, and I think that's when you get into a world when you actually cannot insist on consent across the board generally. I don't think we will move to that because, practically speaking, there's just such a wide variety of interests within Canada and it's always a balancing. And so I think that balancing will always have to remain open. In the northeast of British Columbia, where the negotiations are as a result of the Yahey case, we know that there's a table with all of the Treaty 8 First Nations, or there's multiple tables with each of the Treaty 8 First Nations being consulted. So the government is absolutely being faced with, and proponents also by association, being faced with dealing with different interests, overlapping claims. And I think in those cases, it'll always have to be a balancing, but we've yet to see it play out. And I think the consent agreements we will first see in areas where there's not overlapping interests, or where the First Nations have aligned together. And we see that in the Lower Mainland too, where the First Nations within the Lower Mainland of British Columbia are working together as opposed to setting out opposing interests. So
I think strategically it makes sense, and that would be the most likely way that an agreement with overlapping interests would occur. In Alberta, it would be very difficult to align all of the Treaty 8, Treaty 6, Treaty 7 signatories into alignment on an agreement unless they had already expressed interest of that nature. I think it gets even more complicated in a province like Alberta, where under the Natural Resource Transfer Act, part of the deal was even if you're a Treaty 6 card-carrying member, you've now got rights to go harvest, fish, trap, hunt in Treaty 7 or Treaty 8. That was part of the deal when the feds transferred control of the Crown lands over to the province. I had one maybe last follow-up question for you, Bridget, unless we get any further Q&A. We seem to be moving through the litigation directives and the consent agreements and that type of thing towards resolution, which has always been sort of the Supreme Court of Canada's direction, that it's always better to negotiate a deal as opposed to litigating for your interests. Is this just pushing litigation down the road where we're no longer seeing cases dealing with pure Section 35 rights type litigation and now contractual interpretation litigation down the road where one of the parties disagrees as to what the intent was when they negotiated a particular clause in one of the agreements or treaties that they reached with the Crown?
Well, I'm curious to hear your view and Chris's view on that, but I think it could be, Brenden. I think we see ebbs and flows in the trends and in the use of the courts in this area, and I'm afraid I don't like to admit that I've been practicing long enough that I've seen ebbs and flows myself, just in the scope of practice. And what we're coming out of right now is a pretty heavy litigation intensive period where there was a lot of infringement actions, and there still are others. Like there's this cumulative effects action by Yahey. Beaver Lake is still out there. There's one in Saskatchewan, I believe it's Carry the Kettle First Nation. There was a few just big trials in Ontario, one about treaty benefits, Restool, and another about title land in Georgian Bay area. There's there's another title trial in British Columbia that just finished. Anyway, I think we're coming out of a very heavy litigation period where First Nations are attempting to negotiate. Does that mean it's pushed down the road? I think likely, but I don't mean that in a cynical way. I think I mean that as there always is a give and take in the law here, right? And in the negotiations. Maybe I mean in a hopeful way for me as a litigator, but I think there's a time period then when the negotiations and the policy changes and that either slows down or comes to a disagreement, and then you access the courts, right? And then it changes again. So pushes down the line, I think, is not the words I'd use, but is this an ebb and will there be a flow later on? That's my prediction. I don't know if others have thoughts on that.
Yeah, I mean, I tend to agree that we're in an era or a time now where we have expressions, sort of sympathetic expressions coming from decisions that are coming from the courts. And, we similarly have, I think, governments, not universally, but in many cases, which are, taking steps, in the footsteps of advancing reconciliation that I think is orienting things more towards what you described, Brenden, as the agreement era in your question. But in terms of where that ends up, I think it's ultimately going to be, that will be determined by where, parties find their best footing will be. But the implementation of the litigation directives, I think, is going to have, certainly Untitled litigation, is going to have a significant impact on how those cases are dealt with and how they arise in the future and the circumstances in which they arise, and the extent to which similar directives are rolled out, in other jurisdictions is going to also fuel that change and how that gets dealt with more broadly.
I think the one interesting thing, and I think this goes back into overlap in territories, will be, okay, it's settled that agreement was reached with the Tahltan. Will there be challenges from groups within the Tahltan that say, yeah, they speak for the majority, but they don't speak for me? So we're challenging the validity of the agreement, full stop. Will the Crown be careful to make sure that it's actually got all of the core representative groups that are privy to the agreement, or where there'll still be other groups that want to be involved? That will be something I'll be watching very closely.
I had another question for you, Chris, which follows from the Beaver Lake Cree case. And I'm wondering if implicit or explicit, as I hear you describe the case, it seems to me the fact that the Beaver Lake Cree is a government versus another private party, right, or individual, but because they're a government who has governance issues that they have to manage and fund, played into the court's role. And I'm wondering if that was implicit or explicit in the decision, and if you think it could have application outside where the litigant is an Indigenous group who's in fact a governing body within our country now.
Right. So, I mean, I think it wasn't sort of expressly dealt with in that, the fact that, that the analysis would only apply in cases involving Indigenous governments, and that was what the court was intending. But I think the focus and the rationale for the change to the impecuniosity branch of the test certainly was made on the understanding that and based on the fact that they were dealing with an Indigenous government which had to make decisions about where to allocate funds. And so I think it's implicit, certainly, from that standpoint, that's where the analysis, is being driven by. For sure, I think that the analysis could extend beyond sort of governments per se to other groups which occupy, a similar position and have, an analogous obligation to members, for instance, to use funds in ways that are, maybe necessary to do, certain important things and to ensure that certain important things are done, and that if those funds are used to advance public interest litigation, that those things could not be done. So I think it can be extended, and I think other groups and other circumstances will certainly try when dealing with public interest litigation. Again, the threshold is that this all has to be public interest litigation, and the advance costs are a tool of last resort. So they're not, this is what you come to if you truly have no other avenue and you are in a situation where, but for the advance costs, your litigation will not be able to proceed. And taking Beaver Lake as an example, that trial in that case was expected and scheduled for 120 days, expected to cost upwards of $5 million. You're talking about a massive legal expense, and that $5 million is in addition to $3 million that had already been expended. So you're talking about huge expenses in what truly are cases that are not limited to very narrow sort of private actor issues. So in similar cases dealing with bona fide public interest issues where there are no other means and some analogous circumstance can be found, I'm 100% certain that parties will try and do what they can to bring themselves within the advanced cost regime, because why would you want to fund that yourself if you can get the government to fund it, particularly when we're talking about huge expenses of money.
Yeah, thanks, Chris. It's partially leading up to, I've got a nice wrap up question in the Q&A, and we're almost out of time. So I'll use that as my final question, and it's to all of you, but it's partially related to one of the trends that we're seeing, which is that Indigenous nations are getting a bigger and bigger role, not just in resource development, but generally. And so we are dealing with them as another, and I'm not speaking legally or constitutionally here, but as another level of government. And it has aspects everywhere. It has aspects in almost all legal areas of dealing with Indigenous groups. And the good wrap-up question that we have from the audience that I'll pose to each of the two of you is, what are you seeing as the common issues in your practice? And I think the practice of in this area as it relates to Indigenous law, but as the common issues, both either for the non-Indigenous public and the Indigenous public, and to have those changed since you've been practicing. Brenden, why don't you start us off with your thoughts?
I think for me, one of the interesting clarifications that came out of HIDA was that it's not industry's role necessarily to consult. That's a Crown obligation, the duty to consult. And in those early days, where the project proponents were out there consulting on new projects, certain proponents viewed it as a check the box exercise. And then that evolved as Indigenous rights continued to be interpreted. And as we saw Mikisew explaining that, no, there is a role for proponents to play here. Substantive aspects of that duty can be delegated to industry. We moved from a check the box regime to an impact benefit type regime where, okay, well, if you're going to be impacted by this, we'd like to see you benefit from this project as well. A lot more one-time payment type things. And I think now what I'm seeing more and more in my world is equity type participation in the projects where there's a longer term interest in it for the communities to partner up. Like the AltaLink example was one of the first examples of that we saw in Alberta. The long-term stream of funds, I think, makes it easier for chief and council, at least as it pertains to my First Nation, the Cree, 7 generations. We have to make a decision and a recommendation here. That's not only for our benefit here and now, but that's the right decision for the next 7 generations. And I think when you've got long-term infrastructure, when you've got transmission lines midstream, it makes it a lot easier for chief and council to go back to their communities when they're now a full owner, they're a partner in that project, and the flow of economic benefits will be for the longer term. So that's the transition I've seen over the last 15 to 20 years.
Brenden, I think that was very well said, and a nice look into our future for the long term. So I see that we're out of time, so I'm going to forego your answer, Chris, and my answer, and leave it on Brendan's eloquent answer, and wrap up the seminar today. Again, thank you very much for having us. Thank you, Michael, for introducing us and to Fasken's PDAC organization team. The seminar will be available online, this recording, if you do want to revisit it. And Chris, Brenden, and I welcome your questions at any time. Thank you for attending.